If you're advertising that you have a warehouse and it's climate controlled and you don't have a climate controlled warehouse, you're probably going to be sued for deceptive and unfair trade practices.
Hey, welcome to Smart Talk, where we help you go from truck to CEO by working smarter, not harder. I'm your host, Sanitay Zubia, and today we're talking about something every mover hopes they'll never get into, but absolutely should be ready for. And that topic is legal trouble. Is claims, demand letters, angry customers, reporters calling you. It can get really scary really fast. And one wrong move can cost you way more than that job was even worth taking. That's why I'm joined today by Michael Greenberg, a commercial litigation attorney who helps moving companies navigate legal messes before they become a huge blowup. Michael, welcome to Smart Talk.
Thank you so much for having me. I'm happy to be here.
I'm really excited about this topic, not because it's fun, but because we want people to avoid getting in trouble. It's the stuff that you don't want to deal with in your business, but when it's a problem, it's a problem. Movers usually aren't thinking about this until something's gone wrong. What are some of the most common ways that moving companies are ending up in legal trouble today?
A few different things. Moving companies often start without having the proper documentation created for them. They do it themselves or they don't check what the current laws are. So I speak to some motor carriers who haven't drafted the bill of lading according to what their tariff says or pursuant to like what the applicable law is. And that's where they get into trouble. Another way they get into trouble is they don't have the shipper fill out all of the portions of the bill of lading that they need to as they're trying to rush or because their employees are doing the moves are not experienced enough and a document gets missed. And then, of course, issues arise with moves. The larger the company you have, just based off of volume, you're going to run into a problem where a move didn't go the way you wanted it to go. Maybe an item got destroyed, maybe it got lost or damaged. And a lot of my clients contact me when they get a demand letter or even a lawsuit that's filed against them. In some cases, it's a shakedown. A shipper spent $10,000 on a move. Everything went perfectly. And now the shipper is saying, this is wrong, this is wrong, and this is wrong. And now the carrier is going to have to spend money on legal and it's going to decrease profit margins to try to fight this shipper's erroneous claims.
It's not always even the mistake, it's the reaction to it. They're not prepared to react to this, right? It's a two-sided fold. It's like preparation, but then also being prepared when it does happen, inevitably when it happens.
Right. You're correct. When a inexperienced employee, or maybe an employee who isn't properly trained, says something out of a reaction, it could put liability on the company when there shouldn't have been liability, or it could have been contested. So it's very important to have corporate training. So an employee knows when they receive an email from an upset customer or a phone call from an upset customer, don't say anything. Just listen and then say you're going to speak to your superior and you'll be back in touch with them. And that way, everyone gets a chance to come together and figure out a game plan.
That's the stuff that really freaks owners out about their business, right? Is that inevitable letter from an attorney or that call from a reporter? I don't know how many times I've seen it where somebody's like threatening, like, I'm going to go to social media, I'm going to go to Channel 6 on my side. What should the moving company owner do immediately, and what should they avoid doing?
I'm a big fan of having an attorney to act as a sounding board to make sure that your response is the appropriate response. So if a client posts something on Facebook or Google review that is false, and you can prove that it's false, it could be defamation. So you would send a cease and desist letter, whether they're a shipper or they're a competitor pretending to be a shipper, which has happened, and you get them to take it down. And if there's actual damage to your business, you can sue. But if you get a call from a reporter, send it to the attorney because you want to craft the appropriate response. I've had clients who've been contacted by reporters, and I've had to send cease and desist letters to reporters who just don't have the proper research done, and they think that my client is responsible for this when it really had nothing to do with my client, and it was a previous owner or a completely separate company. So you got to keep everyone in check and don't be quick to react. You have to have a planned response.
That's the key term there is planned response. Like as owner, it's not your job to go argue this, right? Your job is to stop and protect the business, and having a plan, having legal counsel, making sure that your team knows what to do if this situation arises. For our movers listening, I hope you're keen into this. If you don't have a plan right now, start asking those questions. Michael, I know that you have been involved in some, without naming names, of course, like some really crazy lawsuits that you've had to deal with, and real stories from the moving industry.
First of all, I've been involved in litigation representing carriers for about 7 years. And litigating on behalf of a carrier is not the same as litigating on behalf of a regular citizen. There are certain laws that are put in place to protect motor carriers and brokers that don't apply to the ordinary person. These laws were put in place by the United States Congress because shipping is an essential part of how this country runs. If carriers and freight forwarders get tied up in litigation, they can't do their job and the whole supply chain will collapse. So Congress enacted certain laws such as the Carmack Amendment, the FAAA, which is enacted to protect brokers and motor carriers against state law claims when it involves interstate transportation. If you know these tools, you can use them to your advantage because that's why they're there. As a motor carrier, it can help you get a lawsuit dismissed. It could help you win a case that you really have liability on, but because the proper claim was not brought by the shipper plaintiff, you're going to win. And I am not blinded by the fact that no one likes to call their attorney because every time you call their attorney, you're paying for their time. But
You're not going to bill me for this, right?
no, these are essential things that you should have set up because it's inevitable for a claim to come across your desk.
If you having legal representation, it's the being able to use these regulations and these laws to your advantage if you have somebody who understands them and is leaning into them and can advise you around it.
And you asked me what are some interesting cases that I've handled.
Yeah.
We had a shipper who was shipping items from one state to another, and she was going to have her assistant meet the motor carrier at the destination to receive the goods. And my client put their driver up in a hotel for 3 days, making four like different attempts to deliver the items to the destination. And the shipper wouldn't appear and made every excuse like a bus collided with a telephone pole outside of her house and there was cops blocking her driveway so she couldn't move, or there was a snowstorm and she couldn't get out. And granted, this is like in a warmer state, not in Maine or anything. And even like pre-litigation, we got a demand letter from her attorney saying we want the goods. We said, okay, well, give us a date, we'll deliver the goods. They never responded. It was just about dragging this thing on and trying to get the most money out of my client. And at some point you've got to say this person is being unreasonable and you've got to go on the offensive. We won the case on summary judgment, and my client still had the items after the case was over. The lady ghosted everyone, and my client had to auction off her items.
That sounds like a scam. Who knows what the items were? Maybe they were empty boxes.
There's no telling because you never know what items you're moving unless you're packing them
Yeah, unless you're packing them yourself.
If the customer is packing the items themselves, I mean, you could be moving pillows and blankets, and the value is nothing.
That's crazy. So nice of them to like take care of their driver like that. Like, and kind of him to even be willing to hang out for 3 days somewhere away from his family. Like, what a hassle.
That's what a good company does. They go
Yes.
above and beyond for their customer because word of mouth is very important.
Yeah, there's even more to this. There's using the law to your advantage versus using it to survive. Where are areas that they can use this earlier in the business to protect them? What should they know and what should they have prepared inside the business that set them up for success there rather than being reactive to it?
Well, I think they should have a lawyer help them set up the business, draft the documents, because there's so much in the documents themselves that protect the motor carrier or a broker. There's disclosures, waivers. If you have those documents filled out properly, you could be saving yourself a lot of money in the event that a move goes wrong. And inevitably, a move does go wrong. You can have a truck flip over in a car accident and everything inside of it falls into a dam and gets wet and ruined. You can have a fire in your warehouse. So it's really important for motor carriers to not only understand their contracts, but also to know their tariffs. There's a bunch of good nuggets inside of a tariff that will help educate a motor carrier, a consumer about what they can and cannot do. For example, storage in transit situation where you're holding someone's goods for a temporary period of time and that becomes a more permanent situation. You need to convert the storage in transit contract to a storage contract because there's liability issues if you don't. So I would just encourage carriers. I know it's expensive. I know no one likes paying their attorney, but to at the very least read their own contracts, look at their tariffs, because that will save you a lot of money down the road.
Yes, it's an investment early on to avoid a bigger risk later. Like, where are their legal risks at today that every movie company or owner should wake up and smell coffee around?
Number one is document retention and ensuring that you're retaining emails between your employees and the customers because you might need to pull those in a year or 2 or 3 years. Same thing goes with audio recordings. You need to ensure that your document retention system is set up so that you can pull an audio recording from a few years ago if you need to. It could help win a case. Second thing that a carrier can do and should do is look at your website. Look at what you're advertising. If you're advertising things that you are not able to deliver, and I'm not just saying fluffery things like, hey, we're the best in the business. That's an opinion. Anyone can say we're the best in the business, and you're not going to get sued for that. But if you're advertising that you have a warehouse and it's climate controlled and you don't have a climate controlled warehouse and your shipper has items in that warehouse that get destroyed, you're probably going to be sued for what's called deceptive and unfair trade practices because you're giving a misleading or false advertisement. I know that a lot of companies hire third parties to put together the websites and maybe even draft the content. Always have your eyes on it because at the end of the day, you're responsible for what you put out there into the metaverse.
Movers here, if you're listening, you want to be proactive. What's the best way to get in touch with you, Michael?
But you can email me at mgreenberg@thefirmmiami.com. You can also call me at the office 305-672-7495, or you can try my cell 954-263-3707. And you can visit us at www.thefirmmiami.com.
Amazing. I'm going to put all of that information down in the comments of this video. Michael, this was absolutely incredible. Thank you so much for spending time with us today, dropping all of this knowledge. If this was helpful to our listeners, hey, hit subscribe so you don't miss an episode of Smart Talk. Thank you so much, Michael. We've got more
Thank
experts
you.
coming to you, like Michael, to help you protect, scale up your business, grow smarter, and get home on time. Thank you so much, everyone. This is Smart Talk. I'll see you next time.